Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Due to some internet maintenance issues, we are not live today. Actually, we were live about an hour ago, but we are not live right now. So we will not have the option of asking live questions. But as always, we will put the speaker's contact information in the description below so that you can reach out to him with questions, or always feel free to reach out to the rest of us with at KTI. Today, we have Michael Panesar out of Houston, Texas with us to talk about a closing argument that Pat Maloney gave. I don't know about you, but I get in my head about closing argument, and that is the last thing we need during an emotional part of the trial. I can always use additional tips and tricks on how to make my closings more effective. So I'm excited to hear how Pat Maloney did it in this case. Michael, share with us what you know about Mr. Maloney, his closing argument, and how we can bring it home for our clients in closing.
Well, thank you so much, Jenna, for having me here. It's a privilege to talk to everybody about this. You know, one thing I say is we stand on the shoulders of giants, and Pat Maloney Sr. is certainly one of those giants. I mean, he is first, let me give you a little bit of a background on Pat Maloney Sr. Born in August 1924, passed in 2005. He was a Marine, World War II vet, Pacific Theater, Purple Heart, married 50 years, father of 5, all trial lawyers, successful trial lawyers too. Over 100 verdicts with $1 million plus. His first multi-million-dollar verdict was in 1976. It's the Inner Circle of Advocates, Forbes magazine, top trial lawyers, King of Torts, and then this, Flores versus Sertagas. It was the largest individual personal injury verdict at the time of December 30th, 1977. So a little bit of background on this case. It happened in Eagle Pass, which is a border town, very small, very poor, rural place, on April 29, 1975. Verduzco was driving a semi-trailer owned by Sertagas, a Mexican corporation dealing in petroleum products. He was towing a container with butane propane product in a container manufactured by Lubbock Manufacturing Corporation. He was rounding a corner as he was coming into town at an excessive rate of speed, and the truck turned over. The container containing the gas hit a concrete abutment and exploded and engulfed about 30 acres, killed 16 people in a mobile home park, 50 people were injured. And Jimmy Flores, Pat Sr. had a couple other clients, but this particular argument focused on Jimmy Flores, who was 14 at the time. They were in a parking lot looking for car parts. He was burned and mutilated over 90% of his body. Only the soles of his feet and the area where his belt was, did he have any more skin? Everything else was burnt. He had past medicals of $198,000, future medical expenses expected to be $429,000. I put that there because, you know, this is 70s dollars figures. That's a huge number in the 70s. So what is the connection here between the reptile and Pat Sr.? Well, Papa Don has said many times that Pat Maloney Sr. was doing reptile long before the book came out. And, you know, I think there's besides they're both being Marines, Irish, and they look awfully a lot alike. You know, they're both Inner Circle members. And, you know, if you study this closing argument, you can learn a lot about what the Edge and Reptile is trying to do. So where did the argument start? The whole old phrase, may it please the court, but and you, jurors, true. And you're going to see that phrase, jurors, true, in a lot of this argument. There's going to be many passages where that comes out. And he's going back to jury selection when he's talking about verdict and what a verdict is. It's the truth. And your oath is to give us a true verdict. So I took from this that he's addressing the jurors and giving them permission, asking for their permission to address them. Now, then he goes on to talk about, I've been trying cases for 30 years and this is the worst I've ever seen. Now, I've been trying cases 25 years and I know there's folks out here who've gotten bigger and better verdicts than me. So I'm humbled at the task that I'm going to try and perform here in talking about such a monumental verdict about a monumental lawyer. This is really incredible stuff when you look at it. So what is the purpose of tort law? That's where the case selection criteria, y'all know what it is. Why are we here? What is the purpose? And so he sets out early on in the closing with a properly designed and built tank, this Holocaust, and again, 70s after World War II, Holocaust may have a different meaning today than it does then, but it was a powerful word. This Holocaust inferno would have never have happened. And so take a look at your state's tort law. What is the fundamental purpose? In Texas, is to deter wrongful conduct, shift losses to responsible parties, and fairly compensate deserving victims. And that's by our Texas Supreme Court. And fairly recently, this is not, old dusty case law. This is recent. Again, this is a horrible tragedy. There's harsh emotions involved. And one of the powerful phrases that just really opened my eyes was, the Lord made us to laugh and he made us to cry. So you have permission to feel these emotions. And it's important to feel those emotions because later on in the argument, he's going to talk about how you have to go in and look at these and you're going to have to feel these. So he rallies the troop with a citizen pain. Don't be sunshine patriots. Don't be summertime soldiers. This is difficult stuff and you're going to have to look deep. And he's going to ask this jury for millions and millions and millions of dollars for pain and suffering and misery. And so he's got to rally the troops. He rallies the troops with, don't be a sunshine patriot. Stand tall. Now, he talks about the meaning of jury service and what the verdict really means. He talks about Thomas Jefferson saying, whenever you're doing public service, when you're in a position of public trust, as you are on a jury, your verdict, you become, and your voice becomes public property. And for the first and probably last time, you have a terrible responsibility of public trust and being public property. So that means you have to consider the public. What do you want in your community? What do you want in the public? This verdict, your public trust, your public property, your verdict is going to become history written in the courthouse for all generations. I mean, look at us. This is what, 30, 40, I can't even count how long ago this was, 50 some years ago. And we're talking about it. And it's very relevant. It's very important. We can learn a lot from this. And he ends this section with, it is only you who can write this particular history. He's empowering those jurors to move mountains. I mean, this is really lifting a jury to a height that's never been reached before. the water cooler talk, what'd you do over, the last few weeks? So we haven't seen you in a long time. Well, do you think you gave too much in that verdict? Well, he answers that question. You're going to be proud members. You had to give so much because the situation demanded so much. And let that be a verdict, be a proud moment in history for you and all others. Jurors, you have the power to make them stop. The bell tolls for you. That means we're all in this together. Your verdict is going to touch you in your own life and the community. Where have we heard that before? We know how important that is. And the role and function that you as a jurors are going to send a message to these corporations, to this business. Scrub up your act. This terrible tragedy may never, never happen again. The plaintiff's expert. I like how he talked about this plaintiff's expert when he said that he was good on direct, but he was even better on cross-examination. And how this useless and unnecessary Holocaust, how unnecessary and useless this explosion was. If you read back to that book I showed earlier, Reptile talks about needless endangerment, but this is the same phrase, same words, just different words, same meaning. If there was competence in a properly designed and manufactured tank, this never would have happened. And the defense likes to talk about cross-examination as a crucible of truth. Well, Pat Maloney Sr., he took that and said, he's absolutely right. I agree with my friend on the defense. Cross-examination is a crucible of truth. And look at what he said in his cross-examination. This was useless and unnecessary. Now, how many times have we heard this? The defense tries to blame the empty chair. And in this case, the empty chair was the dead driver, the dead man. Lubbock was trying to blame everything on the dead man. But he saw that. He called him out on it. He said, they're trying to disguise their own wrongdoing, their own bad acts and pin it all on the deceased driver. But he never would have tipped over the tanker. He would not have died if that tanker was designed and manufactured properly. Some of the arguments was that it had too high of a center of gravity. Lubbock Manufacturing was trying to blame it on a fifth wheel, but I'll show you in a minute how he responded to that. But it was clearly a over tipping when he rounded the corner. Now, Lubbock Manufacturer had the guy that designed this tanker. He was still an employee of theirs, is still working for them, but he didn't come to trial. And then they tried to blame it on the fifth wheel, which is this thing down in the bottom left-hand side. It's the coupling where you put the attachment in the coupling, and it allows the trailer and the tractor to move as two separate pieces. But it wasn't the fifth wheel, it was the rolling over. But they didn't bring Mr. Henderson to trial to talk about the design of his tanker. But they did bring his apprentice, who kept saying, I don't know, I don't understand, I don't know. And so they were trying to bring the apprentice, but not the guy that did the thing. So, that right there was basically an admission that, yeah, this is probably not a good design. And he called him out on it. Pat Maloney called him out on it. Now, the transition to damages. This is let's turn to the grisly audit for pain and suffering and disability. And when you hear the damages, you'll understand why grisly audit is a perfect phrase for it. You know, some of the other phrases in here: child of ashes, preacher of this inferno. In considering the importance of your verdict, I many times referred to the written testament. Your legacy, we all must share in glory and pride, or in dismay and disappointment. I do not, the Cardinal Newman, and if Pat Maloney Sr., he went to Mass every day. He even had a key to the church to open up the chapel in the morning. So he's very well familiar with the Bible and the teachings of the Catholic faith. And he said, Cardinal Newman taught, I do not ask to see the distant scene. One step at a time is enough for me. So one step at a time when they're going through this verdict form for them. So the injuries that this poor man suffered: no fingers, no hands, no ears, little in the way of eyesight. As Dr. Larson said, he is the worst disaster I've ever seen. All harmed beyond repair. One woman described his testicles as large as apples and black and revolting, and he pled, do not let my mother ever see me. I mean, do not let your mother ever see you. That strikes deep. I mean, we all want mama, but he didn't want his mama to see him. There's no pain like burn pain. The Clorox baths, so bad, you scream and scream and scream. The powers of three, millions and millions and millions, you scream and scream and scream. There's no pain like burn pain. The Clorox bath, he's growing and stretching his skin. The skin grafts are, I can't imagine what the skin grafts were like. And just a constant pain. And there's only so much pain pills can get rid of. The rest, you just got to live with. It's always there in these types of injuries. And that's when the mental anguish starts. When the physical pain stops, the mental anguish starts. Talks about how his former friends, saw Jimmy as a monster now. I mean, 14-year-old kid now looks like a monster. His friends don't want to be around him. The doctor described mental anguish as not being able to accommodate to society, never having friends, never being able to go out in public. I mean, good grief. The stares, the questions, the pointing, that's the mental anguish. What would it be like to be so terribly and completely dependent upon someone? You don't even have the solitude of bathroom alone. You can't brush your teeth, can't feed yourself. What would it be like when you know you've already had 2 horrible Christmases and you have one coming up? Remember, the verdict was on December 30th. So these arguments were before Christmas. And each day was getting worse and worse. It's loss of earning capacity. You know that's 0. You and I both know that he will never, ever be able to work. Never play, and he will never, never dream. Talking about a young man who had half a century of dreams, aspirations, and a useful life, who told the damages story. Brought the nurses, the doctors, Jimmy's friends, his teachers, his coaches, pictures of before, pictures of after, all the bills, everything which would enable you to use the handle of your heart from the inside, not for sympathy, not for prejudice, not for passion, but total understanding and total comprehension. Who's been telling us about these before and after witnesses? Now, how to measure damages. We know we got to get to the bottom line on the most devastating history in the entire human spectrum of this explosion. You've got to realize that Jimmy naturally did not want to sell his ears, lips, eyes, which are all gone, or his face, or any other 90% area of his young but mutilated body for any price. But whether Jimmy likes it or not, he has put them on the marketplace of compensation because they are now gone. You must write the price. Of course, he wouldn't, and of course, he couldn't put a price on the pain and suffering he's endured, or that which his mother and father and brother and sister must endure just by seeing him suffer hourly, daily, or really on the sale of the teenage life which was his and which will never, ever be, on the idea of dating in his formative years. Any dreams, aspirations, getting married, children, grandchildren, never, never more. It's now on the marketplace of compensation that the juror has to decide. We've all heard of Mo Levine. It's not what they take away, it's what they leave you with. So what's Jimmy got right now? The children that testified, his former friends, say that he's a monster. He stays in his room, the hospital. He's a social outcast. He's isolated. Now, one thing that Pat Sr. did in this trial that I think is just, brilliance, is he didn't bring Jimmy to the courtroom. He knew that would have been just too much. So they brought pictures. They brought other people to talk about what they saw and what they knew was the result of this injury. Somebody had said that death would have been a blessing, but Dr. Larson said, no, we can never play God. So therefore, God in his wisdom has said that Jimmy must live out his 55 years of life expectancy, literally as a mummy caught up in that scarred body so bad that his closest friend, George, said, I couldn't get up the courage to look at him. And last year, we had Pat Maloney Jr. on the Texas Listserv meeting, and he said that Jimmy lived just about all of those 55 years. He lived a pretty long life after this. So all the growing, all that, Pat Sr. was talking for Jimmy as an old man. The defense likes to say, that we're all about sympathy. The plaintiffs are going to get up here and talk to you about sympathy, but it's not about sympathy. Sympathy is demeaning. Sympathy is charity. Sympathy is inadequate. You want full, fair justice. That is your right. Under the Seventh Amendment of the Constitution, that is your right to come into court asking for full and fair justice, which is better, it's prouder, it's more adequate, more appropriate than sympathy. The old Indian saying, You've never known a man until you walked a mile in his moccasins. That's the difference between sympathy and compassion. So those are some difficult moccasins to walk in when the jury has to look within themselves to figure out this verdict. So Pat Sr. gave an example. If Lubbock's container was destroyed and it cost $1 million to make it, they would be demanding in court, pounding the tables. They want the full $1 million for the loss of their truck, and they would deserve it. They would be right to ask for the full $1 million. But when you're looking at a person, it's difficult because now the jury has to look fully and squarely at this person's pain, this person's suffering, the disfigurement and the mental anguish, the loss of earning capacity, the total bankruptness without any happiness, any accomplishment, without any hope ever again. But that's the only way to get to that full justice. Of course, the defense's take on damages is, the discounted rate. Let's look at the discounted rate. The defense wants discounts on everything. All the harms and losses they cause, they want a discount on it so they can do it again. They need their permission. But the way that Pat Sr. responded to that was, that's why we gave you all the facts, because we knew you had to apply your conscience, your good judgment to analyze those facts and do the right thing under the circumstances. Empowerment. He rallies the troops again. As jurors stand like giants, tall in the realization, this challenge is yours. This responsibility is yours. This verdict is unquestionably yours. And by its comprehension, its wisdom, its fairness, its size, it will resound not in this community, but throughout the United States, making the greatest historical strides in contribution ever known anytime, anywhere. That's taking it and making the importance of it, and the fact that it's going to affect the whole United States. It's going to be important. The whole country means you have to take it with that due care, that seriousness to which it demands. The situation demanded. So in jury selection, he asked if the poor, the sick, the injured, the downtrodden are entitled to ranks under the Constitution, or is it just for the healthy, wealthy? And everybody said, even in the dignity of man, they said that, of course, the poor and sick are entitled to their ranks under the Constitution. The dignity of man rests at the core of the American Constitution and statutory values. Its spirit suffuses every clause, every legislative act. Government's duty is to protect and cherish that dignity and its moral and political force of the whole Constitution and judicial system. And the last analysis, though, of all of this, it must be said, you jurors true are a last refuge of justice. So it must be and shall be, in this case, through your verdict. So in this part, he talks about, in the interest of justice, I would demean for him as I would for any proud or free American, that you give him the right to come into this courtroom, a temple of truth and justice, and prove his losses, and then give him fair compensation. Jurors true, never a gift. Proud people don't want gifts. They want to be paid fairly and squarely and fully for the immense and profound, incalculable losses for which this man has endured. It's never a gift. You want to be paid fairly and squarely. And that applies to any kind of a case where you're asking for damages. Of course, there's only one chance. If you do not do it, then no one at any time, anywhere is going to be able to give him the fair consideration he's due. They have to face the pain, face the agony now and in that verdict. Otherwise, he's never going to be able to get a fair trial. They can't come back afterwards. So then it comes down to the asking for the money. Very difficult thing is what figure. I've said millions and millions and millions, but what figure? Well, obviously you can talk in terms of 10 million, 15 million, or 20 million. We've got a summary here I think is fair on this chart. And he wrote the numbers down and added them up on a butcher paper for the jury to 23,214,000. If you feel differently, that's fine, but we don't think he'll disagree that the total is fair, whether it's more pain, more mental anguish and disfigurement, but the total figure is what's fair. And talked about, went over the Clorox baths and how they burn, the screaming and screaming and screaming until exhaustion and an unconsciousness of sorts arise. How much pain every day. Your job, I suppose, is an enviable one, but in many respects, in many ways, it really is. It's a magnificent opportunity to right a horrible wrong. Some pros to reflect. There's no way is there to describe a young man, age 14, who never had a chance, a young man whose sun is setting before it ever came up, whose moon will never have any light, whose star has already come out from the heavens. Don't we really say in the final analysis, it's only you, jurors true, who can bring his Christmas message. It's only you who can write in the appropriate greeting. And then the last words. Dark and dreadful history has been written by reason of this tragedy, and it is only you who can now write a glorious conclusion to this fatally wounded family. Thank you very much. Now, there's a lot of defense. In fact, I think I saw a defense course now talk about how to stop this. You just got to know your black letter law. Texas has plenty of black letter law about, what is appropriate argument, what's inappropriate argument, and everything that we went through on here is appropriate. It's in the black letter law. You just got to do the research. It's there.
Thank you so much, Michael. That was really powerful. I have not had the opportunity to review that closing argument before, and I honestly was not sure what to expect. The way you delivered that, even just going through those slides, was really powerful. Thank you for doing that for us.
It's a pleasure and a privilege. Like I said, we got to talk to Pat Jr. last year, and that was a moving experience. He hadn't heard his dad's voice since he passed away in 2005. And that was an emotional moment. We all felt it. It was powerful, but man, we stand on the shoulders of giants, and Pat Maloney Sr. was an absolute monster out there. He was a giant among giants.
How to take such a massive tragedy and make it really simple and deliver it with people's words and people's language, and not lawyerly, and not, from a place of I'm this important person and you have to make this decision. I mean, it just felt very friendly and welcoming. I felt like, and
Yeah.
go ahead. Go ahead.
Well, some of the, and I wish Fidel Rodriguez Jr. was here because he has some stories of Pat Sr. that, he was a Marine and an Irishman, and it showed. But man, when he's delivering his closing arguments, you can feel it.
Yeah.
He was touching the nerves of people.
One thing I hear sometimes, and sometimes I feel myself, is, this is a massive tragedy that everybody can come together on and agree it's a massive tragedy, right? You've got a big corporation, somebody who's a bad guy. How do we take what Mr. Maloney did in this closing with such a massively tragic situation and put it into our own cases where we maybe have somebody who has, a permanent back injury, or was in a car crash and isn't burned within 90% of his body? What are your thoughts on that?
I mean, it's a lot. So in this closing argument, Pat talks about three things. He talks about Jimmy and his injuries. He talks about Lubbock Corporation and their whole, the manufacturing and their defense. But then he also talks about the justice system. And he talks about the justice system to rally the troops, to motivate them. And those you can use word for word in any one of your cases. A minor soft tissue whiplash injury to, just horrible infernos and, mutilated bodies. And you can use that, that template to in any one of those cases.
Mm-hmm. Yeah, because at the end of the day, the jury is there to speak for the community about the wrong that was done. And, I think we sometimes feel like, well, that's easy for you to say when you've got this massively tragic incident. Of course, everyone's hearts, the jury's going to be bawling and everything like that. But even on a smaller scale, I felt like I could see myself using some of that language in my, in my smaller cases, right? With somebody who, I got a lot of really good ideas on how to explain the dignity of somebody, especially with brain injury, right? You look at them and they look fine, but their dignity is gone. Just using words like that. We had Adam Anderson on recently talking about power words, and I saw so many powerful words throughout that closing.
Absolutely. Yeah. Oh yeah. He was hitting power words. He knew it. He knew those were power words.
And I noticed it was very time appropriate, right? Like Sunshine Patriot, things like that. Those were things of the time. And so, we don't have to wait for a list of power words to be delivered to us from, Papa Don, although he always does a wonderful, comprehensive one. But we can just draw on what's going on in our community and our society and what people find powerful and utilize that language in bringing a group together and empowering them to do good.
Absolutely. Yeah. And that I think in any case, closing argument is supposed to be persuasive. Mm-hmm. And the way you motivate a jury to move mountains is empowering them. Tell them, hey, you have this power. You can control this. You can tell them, stop. I want this to never happen again. If it's paying attention to a stop sign and stopping, you can have that power. All you have to do is enforce this rule.
Absolutely. You mentioned a little bit about Jimmy and after the trial. Do you know very much about what happened to him? I just kept thinking, we are here 50 some odd years later,
Yeah, no, I couldn't find much. All I know is from what Pat Jr. mentioned last year in that meeting.
So he did live quite a long life. Did you know if he was he ever able to go home or anything like that?
Well, I think he was at home. He had a hospital bed at home. Is what his final accommodations were.
Mm-hmm. That's an interesting thing also for a jury to consider is, you know, there's golden rule and all that kind of stuff. And as Michael said, make sure you know what your jurisdiction says. But that's what a jury is doing, is imagining themselves in that body, in that bed for the rest of their lives. And that's kind of, you know, what ends up being extremely powerful is like, how do you compensate somebody for that? And it really does take imagining what it would be like. And I'm sorry to say it's a golden rule argument, but that's what it takes, you know?
Well, I mean, they have to face it. When in the deliberation, when they're talking about physical pain, mental anguish, they have to talk about it. They have to, and they're going to use their own conscience. They're going to introspect in their own lives. They're going to have to go within themselves to fully and fairly evaluate and consider these things. How can you analyze somebody's pain without looking at your own pain? Mm-hmm. How can you analyze somebody's disfigurement or impairment without realizing, oh gosh, I do have all my fingers, I do have my eyes and ears. God, oh my God, this guy doesn't. Oh shoot, what's that like? I mean, take away your burn off your lips. Everybody's going to be feeling their lips. You're thinking about it's a human reaction. Mm-hmm. But you have to, like Cardinal Newman said, one step at a time. You have to take one step at a time through that.
Mm-hmm. I also really loved how he talked about the value of these things of, Jimmy never wanted to sell these parts of his body. He never would have asked you to, give me the value of my nose or my ears or my lips. And, we have to, I think it's hard because when we ask a jury to quantify something like that, there's no way to do it. And especially things like, loss of dignity or embarrassment or things like that. How do you quantify that? It was a good picture, I think, for me anyways, to have him say, like a supermarket, like a tag, right? This now has been taken away from him and put into the marketplace, and you got to place a value on it. Yeah. And that was super compelling.
Yeah, marketplace of compensation.
Mm-hmm. Yeah, I'd say we're going to have to wrap up in a couple moments, but I just wanted to touch on a few things that I noticed that we all learn in, kind of the courses, and everybody who's listening. If you've been to any of the college courses, you saw so much in that closing argument that we all learn about. And, we can't get into much of it. We don't have the time today, but there are reasons why certain language is used. There's reasons why certain things are in certain places. And so I encourage you to attend some colleges, join in and learn about how to become an effective communicator like this. And we certainly saw, it's easy to blame that driver, right? He sped around the corner, flipped the car, and that's the person who caused this crash, right? Well, that guy's actually a victim of his own company, causing him to drive this unsafe vehicle, and now he's dead. Make the driver the victim as well, as not on the same level as Jimmy, but as well, right? Look at all these victims we have. Don't be afraid to praise your experts either. I noticed that Mr. Maloney did that. He said the best expert here was the one I brought in, and here's why. And he even did better when the defense was crossing it. And I think sometimes we get afraid to talk about how good our case was in that way. So, don't be afraid to do that. Are there any final thoughts that you had, Michael, that you really felt that this closing argument has changed in your practice, or that you've used, or anything like that?
It actually made how I write closing arguments. I'm still working on a few closing arguments, but I think it's really streamlined it, quite frankly, because now I got just three areas I have to focus on: my client, the defendant, and empower the jury. Mm-hmm. And really wave the flag, tell them, this is the rights, it affects everybody. Mm-hmm. And you have the power to make the change that you want to see in the community.
All right. Thank you so much, Michael, for being here with us today and sharing that powerful, powerful closing argument. As I mentioned previously, we will put Michael's contact information in the description below. If you liked today's video, please click that thumbs up to feed the YouTube algorithm. And don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we are going to begin a series that will last for a couple months, a few weeks, wherein we're going to hear from all of the KTI faculty about the undergraduate courses they teach. We're going to start with Benjamin Boscolo out of Maryland, who is the Dean of Rules and Case Selection. Many of us have taken this course, but many have yet to do so, and it is the foundation, the cornerstone of the Edge Symphony. Benji is a dynamic instructor from whom I've personally had the privilege of learning, and I look forward to hearing from him next week along with all of you. Have a wonderful weekend, and I'll see you next time.